It is Texas Rule of Evidence 412. We call this the Rape Shield Law. Please, YouTube, don't censor my video. This is actually about the crime, and we are dealing with legal matters here. Rule 412. It is related to sexual assault cases. It says the following evidence is not admissible in a prosecution for sexual assault, ag sex assault, or attempt to commit sex assault or aggravated sexual assault. Number one, the reputation or opinion evidence of a victim's past sexual behavior or specific instances of conduct of past behavior. The idea here is, basically the defense for these kind of cases before, if you were dealing with a consent issue, is this person has consented 100 times before with every man in the county. The time that she's alleging that there was no consent this time, there probably was. Well, that is not allowed. That is banned specifically by this law, but there are some exceptions. Let's look at the exceptions for specific instances of conduct. You can bring up a specific instance of conduct of the victim's past sexual behavior if these things, okay? One, the courts admits the evidence in accordance with the subdivisions subsections C and D. Two, the evidence is necessary to rebut or explain scientific evidence or something like that of the prosecutor. This is like if there's multiple DNA and, part of the DNA is like the husband's DNA and the other evidence is, somebody else's DNA. You might have to say, okay, well, there's prior sexual occurrences with the husband that are happening. Concerns past sexual behavior with the defendant in order to prove that the person consented. So like has had sex with this person before and not had any problems, has had sex, the past 6 months with this person and never had any issues before. Relates to the victim's motive or bias. So like if you have specific instance of conduct that somebody had sex with this person, she said that it was a rape, it was proven later that it was not, and that there was a lie or there's a motive or bias because they were in the same, I don't know, like a biker gang or something, and she hates everybody in this biker gang. There's a lot of reasons why it could be potentially admissible, but you got to have a really good thing here. You got to have a really good reason. Maybe the evidence is admissible under Rule 609 because it's a prior criminal conviction for that person, or it constitutes some other evidence. And this is all going to be under an abuse of discretion standard that is determined by the judge. And then the last part here about Rule 412 is subsection C, that this is the procedure for offering this type of evidence. Before offering any evidence of the victim's past sexual behavior, the defendant must inform the court outside the jury's presence. The court must then conduct an in-camera hearing recorded by a court reporter and determine whether the proposed evidence is admissible. The defendant may not refer to any evidence ruled inadmissible without first requesting and gaining the court's approval outside the jury's presence. So this is like, you can't just, as a defense attorney in opening statements, say all your evidence of victim past sexual behavior. You have to get a ruling from the judge first. Otherwise, you're committing basically a violation of the law. And the judge could maybe rule that there's a mistrial and it's your fault, and that the state is going to have another crack at the case. So you definitely don't want to do that. You want to be in compliance with this rule. If you're offering evidence of prior sexual behavior of a victim, this rule is the Rape Shield Law, Rule 412. Thanks for tuning in. And as always, these videos are for educational purposes only. It doesn't create an attorney-client relationship. But more importantly, don't forget to like and subscribe if you like what you saw. Leave a comment below for ideas for future videos, or if you have a question you always wanted to hear a legal answer for, we can give you some type of educational answer. If you got a specific question, you need to go talk to an attorney and get a specific answer from them.